but something that, when you get that phone call from the client, especially if you get it with a plaintiff's counsel, is going to board
Absolutely.
a bogus life care plan, you got to say to them, like, we had that one where I think it was a $4 million prosthetics. And you're like...
For rubber fingers. They weren't even eyelid. It was like rubber, like the magician ones where the scarves come out of it, like... $4 million for 2 rubber fingers.
Welcome to The Defense Never Rests with Morgan and Akins, your monthly dose of uncommon sense about all things legal and some that are not.
Hey everybody, welcome to The Defense Never Rests. I am your host, Patricia Baxter, and we have rejoining our podcast today from the first podcast, the awesome group of lawyers, Wendy, Nate, and Oliver. Say hi, everybody.
Good morning.
Lou.
Good morning.
So today we wanted to focus on how to evaluate a claim initially. We all get that phone call from one of our clients or adjusters and says, hey, I just got this claim in. I'm trying to set reserves, or I'm trying to figure out, do I notify the excess carrier? I need help evaluating it. And we have zero information. And that's what this is today. It's a top 10 list of the factors you need to evaluate your case at the very, very beginning with very little evidence. So what we did is, in prep for the podcast, I asked these guys to come up with a top 10 list. Initially, I wanted to do a countdown of these were the best, and this was the order of importance. And what I found is everybody disagreed. So it was virtually impossible to come up with a consensus of a top 10 in specific order of relevance. So with that, I'm just going to throw out our top 10. These guys are going to comment on it. Hit like and subscribe, or comment below if you have or disagree or have any other comments. So number 1, plaintiff's likability. How does that affect a claim or an initial valuation?
Well, I think at the outset you have to determine if the case is eventually going to be heard by a jury or in a bench trial or an arbitration. I sit as an arbitrator in both the Common Pleas Court and the EDPA, and when you have attorneys looking at the cases at that level, we're able to, I think more than a jury would be, cut through plaintiff's liability and apply the law and really assess damages appropriately. I think judges do the same thing during bench trials. I think if it goes to a jury, it's a whole different story, and they'll see in that person, if it's a likable person, they'll see someone that they know who they like and someone that deserves to be made whole, and to hell with the application of the law or the damages. They're going to see that person gets their just desserts.
I think even though you don't have that much evidence when you're and facts about the case when you're first evaluating a case, I think that one of the first things that I do is have dockets pulled. I want to find out if they have a criminal history. And I think if somebody has a list of criminal backgrounds, lawsuits, civil lawsuits, I think I can evaluate a case based on a plaintiff's likability to a client just on that minimal set of facts unto itself.
And I think especially in this day and age with social media, you get to pull their social media accounts. You get to see how active they are online. You get a sense of you get a sense of who they are online, and then you can at least make some sort of early call on whether they will be well received.
For me, it's a lot less about the plaintiff's likability as opposed to their lack of likability. I approach all of them as being with the assumption that they're going to be likable people, that they're going to be well received and credible and sympathetic. It's only, for me, becomes a real issue when I find that there are significant issues with this person. And in recent years, we've had a number of those cases where, while we understand that some of this stuff may not be admissible and probably is not admissible, it's still a factor, because in some of these cases, the aroma about this person is strong enough to where people can really, it's palpable. I don't know how much more to say about that without getting into specifics, but Nate and I worked on a case where, the plaintiff had, he made less than minimum wage because he was part-time, and he had 6 children, all of whom had been removed from the home by the state. And whether that would have come into trial or not is a different story, but even a whiff of that, and I think a jury is gonna change their opinion of this guy.
Yeah, I mean, you get into child support issues, you can get into crimes, thefts, things like that have some bearing on evaluation. I think we've all been in mediations or settlement conferences with judges where say, hey, counselor, you have a likable plaintiff here. You got to put money up. And I think we've now, when we have the type of plaintiff that we don't think will present well in front of a jury, we can say, well, we don't have a likable plaintiff here, so it is a triable case. And I think all of that goes into an initial evaluation. All right, so moving on, number 2, the venue. How do you think the venue impacts early evaluation?
We just talked about it with the Philadelphia venue. I mean, I have a case that's suits being filed in Philadelphia. You absolutely want to tell your client right away, you're in Philadelphia County. It's a tough county to be in from a defense perspective.
And again, like we talked about last week, that's not just with respect to jury pool, which we do. We do jury verdict research at the outset of the case. We look at the demographics, we look at the socioeconomic factors that go into that. But then leading up to that, we talked about that last week, the motion practice going towards that. I mean, I think we've all practiced here in conservative and liberal venues, and leading up to, during the course of a 2 or 3 year litigation, you get more wins after wins after wins in conservative venues on the defense, and you see the exact opposite on the liberal bench in a city like Philadelphia.
Yeah, I mean, I think that's certainly one of the questions when we get that phone call from the client and they give you the factual background. One of the first questions out of our mouths: what venue is it in, or what venue do you anticipate it being in? If it's in a place like Westchester or Montgomery County versus Philadelphia, that's going to have an impact on the number or the range that you put on as far as pure exposure.
Or even change a venue. A lot of times, I've just had a couple cases where they file a suit in federal court and I take the case out of federal court, bring it back to state. That affects the value of the case. And those are some of the factors that I can determine early on.
All right, well, moving on, I have number 3 as injuries and treatment. What do you guys think about that?
I mean, what the damages are is going to be a key controlling factor in evaluation. I mean, you can have 100% dead to rights liability. That's, I never say it's indefensible, but close to indefensible. But if there are no damages there, or very few damages, you're not going to have a high value.
Yeah.
I mean, it's that simple.
And I think when an adjuster or a client gets that claim and they don't have anything, you need to tell them, you need to call the plaintiff's counsel or claimant's counsel and get the bullet point list of injuries and then the treatment. And if you can, get them to send you medical records. But that should be the baseline for every peer evaluation early on, is the difference between a surgery and a non-surgical case, a displaced fracture versus a non-displaced fracture. The level of herniation and all of that has a huge impact on evaluation, because it goes to pain and suffering. And pain and suffering, for the vast majority of your cases, are going to be the largest component of a jury award or a bench award. So you have to absolutely find that out. And it's oftentimes pre-suit, the plaintiff's counsel won't give you the meds before the accident. They won't let you know any of the priors, and you're going to want to know that. But if you get the medical records, you have a shot of at least the priors being in those medical records. So,
or ask for if in certain cases, if they have a demand package that was sent to the carrier pre-suit, there you should see some pertinent medical that can help with your initial evaluation as well.
All right, moving on. Number 4, the plaintiff's attorney.
I don't think this could be overstated enough. This is a major factor in how we evaluate cases. I guess it shouldn't be. We should evaluate it just on the merits of the plaintiff and the injuries, but we take this into account, and there's good reason to do so. I mean, we've had lots of cases in this office. I can think of a couple that looked a certain way, and we removed it to federal court, and I've gotten emails from plaintiff's attorneys saying, I don't do that. I don't practice in federal court. I'm admitted to do so, but I refuse. I'll take whatever offer you give me. Now, that's not a good thing to say. It's borderline problematic. But I think that, really good attorneys in all of you and I can think of a couple we've dealt with that really do their work. And I can think of a lot of them that don't, and just file and they say, I filed a complaint. Here's what I allege, without confirming that at all. I want this amount. And then they sit on it for 2 years. And at the end of the case, they say, oh, crap, I haven't done some of the stuff I should have done. And there's people on the other side that we hear from every day, and we I think prefer that. I mean, I think it's easier to deal with that while it's frustrating at times than someone that doesn't budge and doesn't do their work. So I think that's a huge factor in how we evaluate cases.
Yeah, more specifically for me, I want to know whether my opposition values the case as an investment, are they going to be pumping money and effort into their case to make it better? Because there's an awful lot of them out there that are, I call it the Ron Popeil method. It's set it and forget it and walk away. And then Nate's right, you close up on the end of discovery and they're like, oh no, I don't have anything. Or I have very little. Or in the case of our products practice, what do you mean I need experts? That's big to me. We have a really solid plaintiffs bar here in Philadelphia, and I would say about a third of the firms that we cross paths with really do prepare for war. They're ready to roll, and they and similarly to that is, are they risk averse or not? I started my career as a plaintiff's attorney doing low level, slip and falls, red car, blue car kind of things. And that firm absolutely under no circumstances would invest any money in a case. If they had a significant case, they'd farm it out immediately. It would be, to any one of a handful of firms. But the idea of hiring an expert was just like laughable to them. Like, what do you mean we're gonna have to put $1,000 into this case? Just take what they'll give us. Those are the risk aversion and the willingness to spend money are the biggest questions I want to know, because there's an awful lot of bluster that takes place leading up to the impaneling of a jury, and then once they get within the arm's reach of the courtroom, it's like, oh boy, what have we gotten ourselves into? Then again, I say it, I've said it once and I'll say it again, is that we generally come up against really good attorneys who are doing their jobs and doing it very effectively. Nate and I, in recent memory, have had a couple where you're like, what's Clown Shoes doing today? They disappear, they don't respond to anything. You don't answer things like requests for admissions. I mean, how do you let that go?
Right.
Yeah, I mean, I think those are all great points. And even if we've never dealt with them, you can also tend to look online and see what kind of presence they have, and you can give your recommendation to the client on like what you said, Oliver. Are they going to put the time and to take this to trial, or are they more of a volume practice that just cares about closing files, and that impacts what the ultimate pure exposure number is, because you can get it. I hate to say it, you can get it for less for the plaintiff's attorneys that don't invest the time.
I don't hate to say it, it's the truth. I mean, if you're practicing the Ron Popeil method, that's fine, but be aware that, we know that.
All right, so moving on, liens. Number 5, liens.
Well, I think one of the things that you can evaluate pretty early on in a case is whether the case stems from a workers' compensation lien or case where there's going to be a subrogation lien against your third-party case, and that's going to affect the value of your case, because if somebody has been paid workers' compensation for medical and for wage loss or indemnity benefits, and the total lien is $500,000, you automatically have $500,000 against you going into a third-party case where they know that they have to settle the case. They have to make that case be valued somewhere higher than $500,000 because that money comes back. It's often negotiated at the end. Sometimes I'm able to negotiate workers' compensation settlement and a third-party case globally, knowing that going into the case, that's the goal. Sometimes the workers' compensation case is settled. So at that point in time, you need to evaluate those types of liens right off the bat.
Yeah, I mean, I think, knowing the lien, that your client or adjuster needs to ask the claimant's counsel or plaintiff's counsel, what's the lien? And then you also have to know whether that lien is boardable, and that varies by state. In Jersey, or Pennsylvania, you can board things that you can't necessarily board in New Jersey. So you have to know the difference, and maybe that's where your counsel can help you on that.
And I like to know, is it a legitimate number or not? Because oftentimes we hear, there's a $500,000 lien. And I'm like, well, the guy was 85 years old. Part of this is Medicare. He had a heart condition. They're treating him for other stuff. It has nothing to do with this. I think it's counterproductive to look at this gigantic number and have plaintiff's counsel predicating their evaluation, including that. I found that it's it's much better to be on the same page with plaintiff's counsel, and they say, look, we're going through this right now. Probably about 15 or 20% of this is accident related. The rest is, it's particularly when we have elderly plaintiffs that happens. But sometimes they just don't want to compromise it because they want that big number to put on the board. But I actually think that's counterproductive.
See, very early on in my practice, I had a trial which involved a very serious injury. And you knew that the plaintiff, even at the onset of the case, was going to get money. It just was a matter of which defendant was going to be paying that money. The person was hospitalized, almost dead, for over a year. With that, at the trial, during the trial, we were debating whether or not they were going to disclose the workers' compensation lien. The workers' compensation lien was over $1 million. And when they did the closing arguments, plaintiff's counsel told the jury right up front, going into it, this is the amount of money that he was paid for workers' compensation and what that meant. And that was a big surprise to a lot of the defense attorneys as to whether or not they were going to disclose that. But he did that knowing that the jury award that he was asking for had to cover that amount of money.
I think oftentimes we break down demands and offers into what's being put in the plaintiff's pocket, right? We often say, well, it looks like an X number, but what's the Y number? What number are we putting in the plaintiff's pocket? And you have to think, the attorney is going to take 30 to 40% of it, and then the lien. And so if you offer $300,000, the casual observer would say, well, then plaintiff's going to pocket $300,000. That's pretty nice. Well, their attorney's getting 100 to 120 to 130, and then if there's a 5-figure lien, you have to take that into account because what's being put in the plaintiff's pocket, I think, is the ultimate figure that we need to worry about, and liens heavily impact that.
One of the things to think about, though, is we're viewing this through the Philadelphia super liberal lens, but we've done, mock juries and panel discussions and background preparing for trial in conservative venues where we hear panelists say, the guy's already been paid. He's never going to pay that back. $1 million. I had 5 discs removed. I didn't get that, So that's somewhat less common, but the more conservative, I hate to say, but more rural that you get, the more likely that is. That really doesn't seem to be the case here in Philadelphia, though.
Yeah, and just before we move on, one more point on liens. If you are a client or adjuster and you get that demand package, and the demand package has medical bills in it, you got to just make sure that the bills are boardable, or if part of it's been paid. I've been in mediations, pre-suit mediations with plaintiffs' counsels that'll come in with $100,000 in bills, but only 10 grand of it was paid, and the 10 grand is what is lienable or boardable. But they try to put the 100 on the table to puff up the damages. So just a word of caution on that. Moving on. All right. Number 6, past and future wage loss. Important. And how do you figure it out pre-suit?
Well, a lot of it comes out at the time of the deposition. You may get some employment records at the outset, but I think during deposition you ask about their educational history. You build a basis for that. You build a basis for what kind of employment they had pre-incident, when they're able to get back to work after the incident. And one of the things that comes up a lot is plaintiff says at their deposition, I can no longer work. Well, for how long? Well, forever, or for another 5 years, et cetera. I don't feel right. And their doctors have sent them back to work a year and a half ago, 2 years ago, 6 months ago. And you have to evaluate it from that point forward. You also can't let plaintiffs roll with, well, I was a janitorial services director pre-incident. Now I want to be a NASA scientist after the incident. You have to look at their employment history, what they're capable of doing, what wage they were earning beforehand, what wage they're going to earn after it when you do those calculations. But it's very, very important, but you have to be very careful about the numbers that you're getting and the basis for those numbers from the plaintiff or their counsel.
You also want to ask them for their income tax records. Mm-hmm. I did a trial in Harrisburg 4 years ago where the plaintiff going into the deposition was that her demand was $85,000. Then after the deposition, they got a vocational expert to say that the future wage loss of the plaintiff was over $500,000. The woman hadn't worked in a year prior to the alleged incident, and I pulled the income tax records, and in the 5 years prior to that, the total amount of income she made in those 5 years was $13,000. So at trial, the plaintiff side decided not to put up their vocational expert because that number was so inflated. It's also what pushed us to go to trial at that time.
And I think, that's great if you can get to the point where you can ask for the tax returns and stuff. Sometimes you can't. So you can make some assumptions. You can ask the plaintiff's counsel, how old was the plaintiff? What profession was he or she in? And then you can make some assumptions. Were they union, non-union? What kind of benefits are they getting? What's their work-life expectancy? If they're 40, you want to say to retirement age, but more often than not, the plaintiff's counsel is going to say, he was going to work past retirement. This profession, he would have worked to 77. And that is the biggest difference likely in the economic number on a future. So you can make some assumptions. It's not perfect, but when you're trying to just get an idea of value, that those are the questions the plaintiff's counsel should know off top: age and profession. All right, so moving on, life care plan. Number 7, life care plan.
The ultimate BS.
You want to expand on that, or is that all you have to?
There are very few things in our practice that I see that I look at and I go, come on. Like, how many times have we seen, that this person is going to need new shower handles every 2 years, new, assistive devices that are permanently affixed to a house every 2 years. Do hospitals replace them every 2 years? No, they don't. A person's going to need my absolute favorite are the ILMs, the myoelectric devices. They might not even be a candidate for it, but they get somebody to write a plan for it. He needs an ILM, and by the way, it's $1.5 million every 2 years, irrespective of the fact that he can't even use the thing, and that they have a super low success rate, and that if you wait too long after the injury, it doesn't work anyway. It's just, I really wish that more people would look at it and make sure it passes a smell test, because I think in many cases it actually diminishes the credibility of the other damages.
But something that, when you get that phone call from the client, especially if you get it with a plaintiff's counsel, is going to board
Absolutely.
a bogus life care plan, you got to say to them, like, we had that one where I think it was at $4 million prosthetics. And you're like,
for rubber fingers. They weren't even island. It was like rubber, like the magician ones where the scarves come out of it. Like $4 million for 2 rubber fingers.
But they're going to try that, so you have to have that conversation at least.
Absolutely, I have somebody that lost half their leg. Mm-hmm. They have already had 2 replacement prosthetic legs, and over the lifetime of the remainder of his life care or whatever, he's probably going to need at least 1 to 2 prosthetics. And that right on the onset of the case. So that's going to be something you factor in.
So I think, those are the conversations you want to have. And even if you discount it, you need to rule in, is there potential of a life care plan coming on the table? And if not, then easy to rule out. But if it is, make some assumptions on what that future medical care and cost would be like. For those, we pull old life care plans of ours and we say, all right, what did they say in this case? So you give an idea. Again, it's just to get an idea of value. It's not necessarily to put it in stone and saying this is what a jury is going to come back on. But the first week of a claim, you got to have some sense of where it's going. All right, number 8, and Oliver and I disagree on this, but liability.
Well, let's just have you guys battle it then. Go ahead.
How do you think liability has a big impact on pure exposure?
It's the number one thing in any case.
I'm going to agree to the bane of my existence, I'm going to agree with Oliver on this one, because you don't get to damages if you can't prove liability.
Yeah, but the question is, when your adjuster calls you, is if the plaintiff hits a home run. Mm-hmm. That's the question, because you can have the best liability defense in the world, but you have to plan for the worst. And if your liability defense doesn't work out, what does it look like?
Sure, I get that, but I mean, imagine a case where you're defending the manufacturer Steel who makes chainsaws, and it turns out the guy wasn't using a Steel chainsaw, he was using a Husqvarna chainsaw. That changes all of this other stuff.
But let me make a point. That you said it turns out, that's after discovery. That's after some discovery.
What if they're scene photos?
Well, would you have them in the first day? I mean, the point of, I think, the list, and correct me if I'm wrong, is the first call with the carrier and the client, day 3. And we won't usually know that. We may know that in a month. We may know that in 2 months, in 2 years. But I think...
And I think, sorry to cut you off, but I think liability does play, because how a jury sees a defendant's conduct, what they did or didn't do right, does impact numbers. If they really want to punish you, like we saw in the J&J $8 billion award, then they'll punish you. So what you did on the liability side, or what the plaintiff did on the liability side, does impact. And I think that's where a discussion happens. When I'm assessing pure exposure, I rarely put it, at least in my top 5. It's the other ones we've already talked about.
Yeah, I mean, when I was doing mostly the auto industry crashworthiness stuff, it's a 3 a.m. single car accident. How'd that happen? Bet it was a deer, right? You know,
it's always a deer. All right, number 9, the credibility of the client employees. How does that impact, and how do you figure that out pre-suit?
Well, when we get suits in, it's no secret that we'll talk to the folks that are our clients that were either eyewitnesses or know the policies or were around or filled out the incident reports. And we also speak to, just as a matter of course, their supervisors and their managers. And similarly to number 1, which is plaintiff's liability, our defendant's credibility matters quite a bit. I mean, we've had cases where I've called 5 eyewitnesses. They all have not spoken about it, and they all say it happened a particular way, and they're all consistent. They all present well, quote unquote, over the phone. And I've had cases where I've called 3 or 4 and they have completely different stories. They've made things up. Things are fudged here and there. And you can tell that at the outset. So if you have in the first 5 days, you pull plaintiff's report and they have no criminal history. They're angels. You look them up on social media and they're hugging bunnies and puppies. And
can you hug a bunny?
I think you can hug. Yeah. And then you talk to your folks and they're going to be deposed at some point, presumably. And they present exactly the opposite, that could work against you quite a bit.
And I think, some of these cases you get a repeat clients, and so you have a sense of their employee pool. And if you have a high turnover employee pool, that can impact things. You can look at their employer files and things of that nature. All right, so moving on, the last factor, number 10, I'm going to credit Oliver for this title, is the dark matter. Or as Nate says, societal issues, the unknowns, the things that are going on in the world that could have some relevance in your case and impact value. So talk about those.
Dark matters to me are super important. Like I just said, the accident occurs at 2 a.m. On a Sunday morning, meaning after Saturday's partying. The person is leaving a known section of town where there's, if we were here in Philly, it would be like South Street or something. It's a high-speed single-car accident. Everybody who's going to be sitting in the jury box knows exactly what's going on, even if there's no additional information, such as an arrest or blood alcohol or drug test at the ER. Everyone knows. Everyone knows. That's important to me. Similarly, when we're in less diverse regions of the state and the country, sometimes we see intrinsic biases pop up, and it's interesting because I was talking to one of our engineers who works in the field of outdoor sporting equipment, and the lead engineer for the particular client he was representing had an extremely heavy Chinese accent, and they're sitting in a very rural district with a very rural jury talking about a device used for deer hunting. And this guy has designed this thing, and this engineer was just telling me, like, you could just watch the jury go like, really? He said it ultimately did not play out well for them. But that's what I'm talking about in terms of dark matters. Additionally, like Nate and I's case, where the guy had all of his kids removed from the home, and I questioned him, and I said, well, why? And he says, we were just too poor. Well, they let you keep 2 of 6, Why were they removed? And if even a tiny bit of that leaks into the case, I think it makes a massive difference. Those sorts of things are what I'm talking about.
And I think, like, I just was in a mediation last Thursday and having a conversation with an adjuster where he was asking our opinion on how to evaluate sexual misconduct. Like, there was a case he had where a doctor did some inappropriate behavior, and he goes, in the Me Too movement, how do I evaluate that 20 years ago or even 10 years ago? I'm pretty sure I could have evaluated pretty consistently, but the environment is completely different now. So it's stuff like that. Or the case that we had in Baltimore, which was right around, was it Freddie Gray, I think? And it was right around, and we had, and I won't go into the facts, but it was similar as far as similar factors at play. And I think they filed it 2 days after he died. And we had to talk about what's the impact, because it was in Baltimore, what's the impact of that on this case? So I think that's the dark matter, too, the societal issues that...
And I personally think, scientists now think that dark matter may be the majority of what the universe is made of. I actually think in litigation it might actually be the same.
All right, anybody else have any comments on dark matter, societal issues? That is our number 10. And all right, so that wraps up number 10. A couple runners up I'll throw out at you guys because we couldn't agree on these, but one, prior accidents or issues involving the client, so the claim involves the same thing, a repeat issue, and then the type of product. So we do a lot of product liability, so the type of product is something we want to talk about too. How do you think those two impact how we evaluate cases early on?
Definitely the prior instances involving the client. I handle premise liability cases in town. I had a case where a person fell over something. There was a lot of construction going on, and they had removed trees, and there was a lot of electrical lighting around the trees, and they had left it there. Well, what's the first thing that plaintiffs ask for? Are there any prior suits? So that's one case, and then a couple months later, I get a similar case with similar set of facts, same location, and at that point, that's when you tell your client, you have priors, you have to factor that in. You're going to have to, that there's real value on this case, and you want to try to settle the case. You're not going to try that case.
And the type of products matter. It's kind of, this kind of transfers over the dark matter, what we just talked about. But we had a case, and it wasn't a shooting case per se, but you had a case involving a gun, and I think those cases are infinitely harder to deal with after Sandy Hook and Columbine and things like that, because you have the entire country pounding the drum for that. Now, that usually fades. Well, for a while, I mean, there's a big groundswell for a month or so until it dies down. This has happened over and over again. But I think if you do that when nothing's happened in the world for a little bit, it's a lot easier to defend than if something happens the previous week involving a gun. But if, we have on here motorcycles. I mean, if someone's riding a motorcycle, what does that tell you about them? Are they carefree and not caring about their safety? I mean, the type of product really does matter in society, especially with what's going on in the news at the given time.
Especially in my mind, how familiar will jurors be with that product? Is this something that they touch daily, weekly, yearly, or never? If it's something that they see or use or come into contact with all the time, sometimes they are less likely to understand the level of research and technology that went into this thing. Try to explain how the stability control program in every car sold in America now works to my father-in-law. And he'll go, it couldn't work that way. It's not possible. And in fact, he did say that. But, that is interesting because it's working seamlessly and you're in contact with it all the time. And if something goes wrong, that reptile brain can kick in and say, that could have been me, or my wife has that same car, or my cousin, or the guy down the street, it could have been me. Whereas if it's, if it's a sport bike, you're like, well, what'd you expect, man? I'm like, you didn't get on that thing thinking it was safe. So.
Well, great discussion today. I'll give Oliver the last word on that, but great discussion. Thanks for joining us today. I hope that this helps with some issue spotting. If you get a claim or a complaint in, you want to have an idea of value, this certainly helps you get started. But we appreciate you joining us. Until next time on The Defense Never Rests. See you then.
Bye, everyone.
See ya.
I am your host, Patricia. Well, let me start that again. Hey, everybody.
Which way can I not move my head, Carrie?
Like this.
That would be that. I think
It's
you
like the
should throw
Fresh
that
Prince,
in.
you know, when he knocked on the doorbell at the end of no? Okay.
An home moment. Wait, what?
The Fresh Prince of Bel-Air, when he rings the doorbell at Uncle Phil's house.
Yeah.
And when like the camera's still going, he goes like this. At the end of the thing. No? Okay.
All right.